Okay, so in respect of Tafawa Balewa governorship constituency, that's where this court that matter affects them, but it does not include Tafawa Balewa state constituency, so they'll go ahead with that one.
Yes.
They'll have the results, maybe they'll hold it until this is over before they can announce the overall results, as it were. But speaking about INEC proceeding with the case, if people are saying, well, in what circumstance can INEC be stopped from going on with the process? So if they are saying, well, in Adamawa, something happened, and in this case, what's the appropriate thing?
No, incidentally, the court is not vested with jurisdiction to stop INEC from performing its statutory duties. You remember earlier I referred to Section 53. The enabling law that vests INEC with the power is the Electoral Act. And in that Section 53, INEC is vested with the power to suspend, withhold, and subsequently declare without judicial intervention. So that power resides in INEC. And
so why has INEC not relied on that section?
The reason why INEC can't do that is because of this judicial intervention. I will call it as a misadventure. It's a process that has come in to stall or truncate the statutory exercise of INEC, the powers of INEC in declaring the result. Is it one that should have been done in the first place? My answer is no. Anyone who is aggrieved, the law is clear. The same law that gives INEC the power to do what it is doing.
But laws have got supremacy over some others.
Yes.
So which one is the more supreme law now in this case?
No, the same thing here. There's not like Constitution. No, the Constitution is clear in terms of what you call functions of the two levels of courts, and that is the High Court, meaning High Court and the Federal High Court, and the Election Petition Tribunal. If what the governor was seeking was a pre-election issue, the appropriate platform is actually the Federal High Court that he's expected to go to in relation to interpretation of provisions of either the Electoral Act or provisions of the Constitution, because these are two creations of the National Assembly. The State High Court doesn't have that power to determine, only the Federal High Court. Now, what has it taken before the court? That's a question you ask yourself. It is in the course of an election, the outcome of which he is probably aware of. Can he do that in the regular court? The answer is no. Because Section 133 of the Electoral Act says any complaint, any grounds you have as regards the outcome of any election or the process of the election, you can only do so at the Election Petition Tribunal. And there are a number of cases in this wise. If my memory is not failing me, there's Agbaso and Ohakim, where the Supreme Court has laid this issue to rest. It has been laid to rest. So why do we... You see, the challenge is, in the face of settled principles of law and constitutional provision, we're still creating problems, heating up the polity unnecessarily. And I feel that sometimes some of these people should be sanctioned. It's unhealthy. It's unhealthy. We shouldn't subject ourselves to all of this.
You said just now that if we are aware, why do we embark on such misadventure?
Yes.
Everyone goes to court with lawyers.
Yes.
The lawyers are aware of the process.
Yes.
So why take the brief?
Now, the question is this. You're correct. Now, under our rules of professional conduct, there's a provision there that anybody who sets out to deliberately mislead the court, even in the face of settled principles, can be sanctioned. It's in our rules. But I'm sorry to say this. The late Mwadialo SAN, Fidelis Mwadialo SAN, said, Nigeria's problem is not in the want of rules and regulations or laws. We have enough, more than enough. It is actually our attitudinal disposition to the observance of these rules, laws, and regulations. We're not there yet, where we are governed, directed, limited, disciplined by the consciousness of consequences of breach of laws. We're not there yet. And because we have not internalized the efficiency and efficacy of our laws, that's why we're where we are.
Okay,
because these are things that shouldn't even happen in the first place.
Okay, let's see if we can take a look at what the governor said, because, I mean, all of that talk about him going to the villa to see the president, well, he eventually spoke to newsmen concerning what and why he went there.
I came to brief Mr. President. I am not seeking any action of Mr. President. You know Mr. President is a stickler for procedure. And what I pointedly told him was, I'm not here to seek for you to interfere on our behalf, sir, but to brief you on what is happening and then what actions that I have taken. I am pursuing the legal angle. And I briefed him, and he emphasized on that legal angle, that is the best approach. The returning officer for Bauchi State, at the end of collation, rejected the results of Tafawa Balewa local government, and then 36 other units spread around 15 local governments of Bauchi State, and ordered a rerun. Surprisingly, we woke up one morning and INEC came up with a procedure that is not known to law. Because where a returning officer has made a declaration, only an election petitions tribunal can reverse that. But INEC is attempting to reverse itself in the case of Bauchi. And when one juxtaposes that of Bauchi and other states with inconclusive election, one wonders why that thing is happening only in Bauchi State.
So clearly, no, but first of all, he said the president is not going to interfere. He just came to brief him. So he now said, well, I am proceeding to court. He says that is the way to go. So no violence, nothing. I'm not going to influence any process. Perish your thought. So the question then is, as he's saying, so
can INEC reverse itself in this? On one hand, the returning officer has pronounced a rerun. Now, INEC is saying, okay, no rerun, we're just going to continue the process. So
and that's why I said, you see, the law on this is very clear. Section 53 is apt on all of this. If a returning officer declares a result in relation to a particular unit and it is examined,
having rejected some,
yes, it is then now examined. INEC, as the independent umpire, can suspend the election in that particular unit and look at it. If it is satisfied, mind you, the returning officer merely makes return in relation to the constituent. Yes. Now, INEC is the supervisory body. INEC reserves the right to say, oh, what we're seeing, Section 53 merely talks about overvoting, right? So if you declare a result and INEC now looks at it to say, come to think of it, how many registered voters are here?
Yeah, but
what is the return that you're making? Is even there that the return can be suspended? Is there in, in that section?
Can the returning officer reject a result at the point of collation? Not at the polling unit.
Same thing. You see, the power is vested. Anyone who is aggrieved in terms of any infraction, the law has also made provision for that. If you're not comfortable, and I'm happy that the governor obviously is a lawyer. The governor obviously is a lawyer. So he is expected to also know what the law is on this. And that's why he said INEC has done something he ought not to have done. But the question you then ask yourself, where do you go to challenge that? Not the regular courts, it's the election petition tribunal.
But if you look at under the management of the margin of lead principle,
yes.
6 there says when there is a violent disruption after announcement of results, including destruction of ballot paper and result forms, the required response is to regenerate the affected results from duplicate copies, fill new replacement result sheets with the approval of the resident electoral commissioner, and proceed with collation of results. Then the expected outcome is conclusion of the process.
Simple.
So, but in this case, if the RO unilaterally rejects the result without conferring with the resident electoral commissioner.
Yes.
In that context, can't INEC revert itself?
Yes, that's the essence of all of this.
Okay, so in this case, the electoral officer,
Yes.
the lady, in this case for Tafawa Balewa, she was summoned by the returning officer, and he asked her questions. Some of the questions bordered on the authenticity of the results, which she said that these are the results. These are the real results. What happened is that miscreants came and they interfered with the process and made away with, I think, Form EC8, EC40,
No.
right? EC8A, and made away with that. And they didn't have an extra one. Because of the pressure from the agents from different parties, they had to use an EC8B to collate the results and present to the returning officer. What should have been the procedure? Should the returning officer in this case now say, let's now transfer, take your results back, go and transfer them into the right sheet and then bring it back,
yes.
EC8A, and bring it back, since you already have the results and the agents of the other parties have concurred to it and have copies of those results themselves. Is there anything wrong in taking that step by the returning officer?
Nothing, absolutely nothing.
So in the case where he doesn't take that step,
Yes.
what's the legal implication?
No, but see, like I keep saying, the legal implication is that anybody who is aggrieved, go to the election petition tribunal.
No, the arrow cannot go to the election to the tribunal.
Who is aggrieved? The person who is aggrieved is a party who participated in the election.
Yeah.
You go to the court.
So what happens to the arrow now?
Is discharge his statutory duties without bond.
But I think the INEC has set up a committee. They've
Yes.
looked at it. I think they're going to have new people who are coming in. So
Yeah.
supplementary elections will go on.
I hope you are aware, for instance, INEC officials also are subjected to what you call some disciplinary proceedings or sometimes inquiry, wanting to know what really transpired in the course of the election. Now, all of that is internal, but the outcome of the result, anybody who is aggrieved, having this information, having these facts, you are encouraged to go to the election petition tribunal to go and seek redress, but not for you to sit back and to simply say no, that this is what we're going to do, and then you now go to the regular court to truncate it. If what you have, look at the presidential candidate of the PDP, despite all odds, despite intervention for him not to go to the tribunal, he decided to go to the tribunal. And he says that, look, I have enough materials to use in determining the outcome of my election petition. And these are things that even the governor of Bauchi State should also embark upon.
Okay, so as it is now, the matter, a certain aspect of the matter is in court.
Yes.
And then we know that there's supposed to be a date for all of this to be concluded, and then there's a date for the swearing in to happen.
Yes.
How or what do you see?
No, there will be no swearing in until the final result is announced.
Wow.
Because what has happened now is that the process has been suspended by virtue of this judicial intervention. Now, that process must run its course and must be concluded one way or the other.
Even if it ends up at the Supreme Court?
Not necessarily. Let me tell you what will happen, except they move speedily. If INEC, now being aware of the judicial procedure, and goes there to raise these legal arguments, and the court says, oh, yeah, I see the point, and now decides to discharge the interim order, INEC is now at liberty to declare. Or the judge says, okay, pending when I determine the matter before me, which is based on affidavit evidence, because I want to believe what was filed is originating summons, and the matter is now determined. An aggrieved party could decide to take advantage of the judicial process by going to the Court of Appeal, but again, if the pronouncement is such that gives the other side the window, and that's INEC, to do what it has to do. Because INEC has a statutory duty. The longer it takes, the more expensive the process is to INEC. So this process has to be determined one way or the other, and that burden is actually on INEC to
Do you think it
discharge.
will get to the Supreme Court?
Well, I really do not know. I want to believe that we will allow reason to prevail after this exercise.
But you
so
said
anyone who is agreeable can then now take it.
You said there will be no swearing in. What then happens if that time lapses?
Yeah.
Will the current government continue if that time elapses? And what can
Is there going to be an interim government?
No, the beauty of all of this is that the Constitution has several provisions. There will never be a vacuum in governance as far as the Constitution is concerned. If the governor's tenure lapses, the Speaker of the House will take over. If the term of the Speaker of the House lapses, the Chief Judge of the State will take over. I mean, it's there.
It happened in Adamawa before.
Yes, it's there. There are constitutional provision that addresses all of this. There will be no vacuum in governance.
All right, Mr. Anderson Quakers, Senior Advocate of Nigeria, thank you very much indeed for coming on this morning.
My pleasure.
All right, so let's turn our attention now to substantive politics, and we're going to Abuja for that now. Mark,